This is a lecture on products liability, and in particular it is about the warranty claims that you can make when suing for harm caused by a defective product. Please keep in mind that there are three theories on which you can sue for harm caused by a defective product. Those three theories are negligence, where you're claiming that someone's conduct was negligent and they caused you injury. Obviously that conduct is some conduct that people engaged in the commercial chain of distribution. Conduct, the retailer, wholesaler, designer, somebody. So you're claiming their conduct was negligent. Second theory is a theory of warranty. We're saying that they made promises to me, the injured party, and they broke those promises, and that's why I'm injured. And the third theory of products liability is that the product itself is a defective product and it caused me injury. This lecture is about warranty, where the argument is that the manufacturer, a retailer, somebody made promises to me, broke those promises, which led to my injury. Now, we need to understand certain features of these warranty claims. First, a warranty claim definition. Let me take a second to explain to you, by the way, that there's a lot of material on the board, and you do not need to try to copy it all down separately. I'm going to spend a fair amount of time on each item on the board so you can add to your notes as we go. First of these has to do with what a warranty is, and it's a promise regarding the product that you've acquired. And the promise is purchased along with the goods itself. And so the law of contracts applies to these warranties because you're buying the warranty just like you bought the car or the lawnmower or whatever the other goods were. Now, you run into problems because conceptually, if I'm suing for breach of warranty, it's really a breach of contract suit. And that's a little, again, some of the certain aspects of it, however, involve torts. You get tort damages for it. So that's why the mix-up. Let's go ahead. So we understand what a warranty is. It's a promise regarding the product that it must be a part of the bargain. When you bought the goods, the promise that they would work a certain way was a part of the bargain, in which case you can then sue. Now, as I was mentioning to you, these warranty claims have certain contract actions and certain tort actions. The reason there's some contract features and some tort features is because the breach of warranty action was for a long time looked at as a misrepresentation. That is to say, I told you the product was going to work a certain way and it didn't. And so that is a breach of my promise, but it can also be looked at as a misrepresentation, where when I told you it would work a certain way, I knew it wouldn't. And so if you look at it as a misrepresentation, you see you've got a tort. If you look at it as just a breach of a promise made in good faith regarding the product, then it's really a contract suit. And so you end up with this kind of a lawsuit that's sometimes treated like contract and sometimes like torts. And so you need to know, for bar purposes, that in a warranty suit, it has contract aspects in that it's a contract statute of limitations. Contract statute of limitations for the UCC is 4 years. Whereas if you treat this under tort law, it'll often be 2 or 3 years. Secondly, the damages that you can get for breach of contract include they include consequential damages. That is, the damages which were, let's back up for a second. When there's a breach of contract, you get the standard measure of damages, that is, those that people would ordinarily foresee for this type of breach of this type of contract. But if you make some unusual damages foreseeable by telling the other party, if you breach the contract, here are some unusual things that are going to happen to me, and I expect you to pay for it if you breach. So they can set their price accordingly. And so when you are negotiating a contract, And the damages you can get for breach are the damages that one would ordinarily foresee, but if you make some unusual damages foreseeable, you can get those also. Those unusual damages that you have to make foreseeable are called Hadley versus Baxendale damages, or they're called consequential damages, and they're called special damages. And what you need to know here is that when you sue for a breach of warranty, that you can get, you treat this like a contract suit for these purposes, so you can get the Hadley versus Baxendale or the so-called consequential or special damages, provided those damages were foreseeable. You make them foreseeable when the contract was formed. For example, I'm buying a tomato washer from you as a farmer. This is a real case. And you tell me that this tomato washer will do a certain number of tomatoes per hour. And mind you, if you can't wash that many per hour, I'm better off hiring some labor to do it. But you tell me it'll do a certain number of tomatoes per hour. And it turns out it won't do that many tomatoes per hour. Well, that's a situation where you understood that if it didn't do what you said it was going to do, I would be economically damaged, and the only reason I'm buying it from you is to reduce my cost. If you increase my cost, I expect you to pay for it. And so that's a case where you might be able to get loss of profits because that was part of the bargain. It was foreseeable when the contract was formed. You can get that if you treat it as a contract suit for purposes of these damages. But these warranty suits are also treated as tort claims in that they are, first of all, there are reduced privity requirements. In a contract suit, if I'm going to sue you, I need to have made a contract with you. And if someone in my family or my spouse is going to sue you about that same contract, you have the argument that that person didn't make a contract with you. And so we need to deal with this privity issue and how much contractual relationship do you have to have in order to be able to bring the suit for breach of warranty. And that privity requirement has been reduced over the years, and as you will see, that it's eliminated for some purposes. And likewise, the notice requirements that happen in warranty suits, that is to say, I can put in my contract that if my product doesn't work the way I said it would, that you will notify me and therefore give me a chance to fix it or something. Or you'll notify me within a certain time after you discover that it doesn't work that way. That's a notice requirement. And that notice requirement has been substantially reduced in the sense that there are lots of situations where you don't have to give the notice anymore. For example, I buy a car from you. You tell me if the car doesn't work the way you said it would, give you notice within 30 days so you can do something about it. Or, well, the car didn't work the way it's supposed to, and I wasn't the one driving. Somebody in my family was driving the car. They don't even know about your notice requirement, or some friend was driving it. They have no idea about this notice requirement. And so it's been abandoned in those cases. And even in cases where I am the purchaser, and there was a notice requirement in our contract, a lot of times the courts don't enforce those notice requirements anyway, particularly in personal injury suits. So the notice requirements have been reduced, privity requirements have been reduced, and so these look more like tort claims in that respect. Now, with that in mind, let's now talk about some of these promises that people make that they then later sue on, these warranties. First, there are express warranties and there are implied warranties. Warranties where the person's got to say, in effect, I'm promising this, and other warranties where the law says, if you sell this goods, you are making the following promises, whether you intended to or not. Express warranties, these are found at UCC 2-313, and an express promise can come in a lot of forms. It can be an affirmation of fact. It can be a promise that the person made that the product will work a certain way. It can be a model. It can be a sample. It can be a mere description of the product. All these things, affirmations, promises, models, samples, description, all these things qualify as express warranties. You can put a tag on the refrigerator and say, this refrigerator works a certain way. That will be an express warranty. The express warranty can even be the name of the product. There was a product called Bayban that was a birth control pill. And obviously the name of the product, Bayban, tells you what it's supposed to do. And that would be treated as an express warranty. Now, one final thing about these express warranties is that there's no reliance required if the message was intended to reach this plaintiff. So if someone in the manufacturing sector, a manufacturer made a lawnmower and they sold it to the wholesaler who sold it to the distributor who sold it to the retailer, and I got it from the retailer, okay, well, any advertisements and such things or tags and so forth which the manufacturer did were expected to reach me because they're encouraging me to buy it. And if so, it's expected to reach me, and the message, whether it actually reaches me or not, if it was intended to reach me, and then that's a promise to me. And by law, that promise is also can be made to whoever else says that the law says is included in this promise. My family or guests, to people who are affected by the product, whatever the code says, 2-318. We'll talk about that in just a minute. So you don't have to have reliance on the promise, on the express promise, just the intent that the promise should reach you and whoever else the law says is included in that at 2-318. So now these are the express promises, and now we turn to the implied promises. And before we start through these implied promises, I want to remind you of three problems, three fact patterns that we're going to use to illustrate as we go. Let me show you what those are. We haven't needed these fact patterns yet, but we'll need them coming up. One fact pattern is from the February 02 California bar exam. One is from the February 97, and one from the February 06. In the February 02, when this was part of the reading assignment, you recall that this was a case where a doctor prescribed some allergy medicine to someone, and the person went blind in one eye because of that, and they're losing sight in the other eye. And the question is the doctor liable for this product? Is this a defective product, an allergy medicine that caused blindness? The doctor did not warn this patient about it, and they're going to end up being liable for that. February 97 is the case where the plaintiff bought a lawnmower, and lawnmower had a number of problems, but one of them is that the kill switch was down here, where near the blades that were rotating, close to the blades, so your foot was in danger when you tried to turn it off with that switch. That's the lawnmower problem from February 97. And finally, there's a car problem from February 06. This is a case where the maker of the car, called Auto Inc., and the child is called Coley, Choli, I'm not sure how you pronounce it, but the child named Coley was sitting in the passenger seat and was injured when the car had an accident and the airbags went off. Now, the builder, Auto Inc., knew that it had a choice of either that these airbags sometimes hurt children when they go off. And they could either put in a switch so the airbag was turned off when children were there. Problem with that, of course, that the driver might forget to turn it back on. And then they could put a sensor in the seat. So if the person in the seat weighed less than a certain amount, then the airbag would not go off. It would cost them $5 per car to put the switch in. It would cost $900 per car to put in the sensor. And furthermore, the sensor was relatively new, and they weren't sure that it would work all the time, whereas the switch, of course, you can make work. So we have the child in the car with the airbags, we have the lawnmower switch, and we have the allergy medicine. And we'll use those examples to illustrate as we go along. Now, getting back to our problem, there were no express promises made in either of those cases, so we don't have express warranties. Where there was no affirmation of fact, promise, model, sample, description, none of that happened with any of those three problems. So we do not have express warranties. But now we come to the implied warranties. Now, there are two kinds of implied warranties. These are implied by law, and these two warranties are at 2-314, which is the warranty of merchantability, and 2-315, where there's a warranty that the product is fit for the particular purpose for which it was intended. Let's go to 2-314. First of all, if you look at 2-314, you see there are lots of implied warranties. But the ones which are most testable are listed on the board. Please take a look at 2-314 itself. And you see one of the warranties that the product is fit for the intended purpose. Another is that it is adequately packaged. Another warranty is that there are adequate instructions about how to use it. Another warranty contained in 2-314 are adequate warnings about the product. And so if any of this is missing, then there's been a breach of the warranty of merchantability. For example, in the case of the allergy medicine which caused blindness to the person, you could argue that that medicine, without adequate warnings, is not fit for ordinary use. And so it breaches this warranty, or fit for the intended purpose. You can argue that a lawnmower with a kill switch that's that close to the rotating blades, where you got to put your foot that close to the blades to turn it off, is not fit for ordinary use, not fit for the intended purpose. Like a chair you can't sit on or stand on is not fit for the intended purpose. Of course, the intended purpose includes foreseeable misuse. Everybody knows you got to be able to stand on a table as well as eat on it. So this includes foreseeable misuse, and if the product isn't fit for that, it's a breach of the warranty of merchantability. In the case of the car, you could argue that that children use cars all the time. It's foreseeable there'd be a child in the car, and that if the airbag going off is going to injure the child, that this car is not fit for the intended purpose, and therefore putting the car out there is a breach of the implied warranty of merchantability. 2-315 is the warranty that the product is fit for a particular purpose, not the general purpose. Cars are generally used to go places, and lawnmowers to cut lawns and so forth. And so if a product is going to be used in some unusual way that is not for its normal use, and you represent that it is fit for that purpose, that's a breach of this warranty 2-315, fit for a particular purpose. The classical example of this was the person who bought some shoes to go mountain climbing, rock climbing in fact, and the person at the sports goods store selected the plastic shoes representing to him that these are appropriate for rock climbing. Well, plastic shoes are not. The person slipped and fell, and there was a lawsuit. And the outcome of the suit is that there was a breach of warranty at 2-315, the warranty that these plastic shoes were fit for that particular purpose when they were not. Now, please notice that the promise can be implicit and it's still okay. In other words, the store clerk doesn't have to say to you, I represent to you that these plastic shoes are fit for rock climbing. They don't need to say that. If you go to the store and you say, I want some shoes for going rock climbing, and I want some shoes that are appropriate for that, and the person says, oh, well, here they are. Okay, that's probably enough. So it's a little bit implicit, but it still works. So the warranty of merchantability could have been used for each of the three examples we have, the allergy, the car, and the lawnmower. And the inadequate instructions and warnings could have been used for perhaps all three of them also. Next, so we've covered the express warranties at 2-313, the implied warranties at 2-314, And now comes the privity problem. The privity problem, the vertical privity, that is to say, let's be sure we're clear. There's a retailer and there's a bunch of people in the commercial chain. This privity problem is covered in detail in the introduction to products liability. You might take a look at that. But to summarize it, if we start with the retailer, there are people above the retailer in the chain of commercial distribution. And then from the retailer out, horizontal connection, there's me if I bought it, and there may be my friends who are using it, or my family who is using it. And even though nobody else is using it, if I bought a bicycle from you and I'm riding it in the park and the handlebars come off and I hit somebody, well, how about that person? They're not family, they're not guests, they didn't buy it. Can they still recover on a warranty theory? And so that that's the horizontal privity problem. We get further and further away from the person who bought it from the retailer, and horizontally, and vertically the people further up the chain. In the case of privity, as you recall from the previous lecture, that the vertical privity, it really is not a problem anymore. That people who are up the chain of distribution, if they make an express warranty, that express warranty is addressed to whoever they intended to receive the message. So you don't really have a vertical privity problem. However, you do have a vertical privity problem if you're going to try to make the person further up the chain of distribution. You're going to try to make that person responsible for some Hadley versus Baxendale or consequential damages. For example, I told the person that I bought the lawnmower from that I have to get this lawn cut by a certain time, otherwise the movie company that's going to come out and make a movie here, they're going to sue me for breach of contract. And I need to be sure that this lawnmower will do the job. I got to get it cut at certain distance and certain time, so forth. And so the person says, oh yes, this will do the job. So I go out to do the job, doesn't work, and I sue. Now I've got consequential damages because the movie company I got damages because they can't use my lawn for the movie, and that cost me damages. But that was not foreseeable by the people further up the commercial chain of distribution. The person that the retailer got the lawnmower from doesn't know anything about that. So you're not going to be able to get consequential damages from people further up the chain. But from the retailer who knew about that, you might be able to get your consequential damages. So the vertical privity does matter if you're trying to get consequential damages. That is, except it matters if you're using Hadley versus Baxendale damages from a remote seller, and the remote seller would be somebody further up the commercial distribution. As to horizontal privity, California says that these promises made by these promises are made to all foreseeable plaintiffs. But the UCC isn't that broad. The UCC at 2-318 says that we're going to give you three choices, A, B, and C. In each state, when they adopt the UCC or parts of it, they can choose whether they want to adopt A or B or C. And that determines how far away from the purchaser people can still sue. If you adopt A says that, now I'm the purchaser, okay, I'm the purchaser, but A says that I can sue for personal injury only, not property damage. I can sue for personal injury only, and that not only can I sue, but my family and guests can also sue, household guests can also sue, just as though they bought it. The way this is handled under 2-318A is it makes family and guests third-party beneficiaries of the warranty promise. And so whatever promises I have that the seller made to me, my family or guests are third-party beneficiaries of that promise, so they are in privity and they can sue also. If the jurisdiction adopts B, it's still for personal injury only, excluding property damage. But the person that I hit in the park with the bicycle, who's a person expected to be affected by the use of the product. Now this is broader than family or guest, but if the jurisdiction has adopted B, then they can still sue. The majority of jurisdictions have adopted either A or B. A few jurisdictions have adopted C, and C is just like B, except it includes property damage, not just personal injury. So this determines the horizontal privity, and the vertical privity, again, if it is an express warranty, then anybody who was expected to receive the warranty can sue. On the other hand, if it is an implied warranty, then the implied warranty will apply to the whoever up the vertical chain, the manufacturer, whoever it is making these implied promises to not only the ultimate purchaser, but also whoever 2-318 says they're making it to the A, B, or C people. And so if a person up the chain of distribution made an implied promise that the car was fit for ordinary use and it wasn't, then family or guest can sue under the A choice. Expected affected people can be sued under the B choice, can sue under the B choice, and under the C choice you can get property damage also. Now here's an interesting kind of an odd situation. Consider the case where I am the manufacturer and I sell the car, put it into the chain of distribution, and now the retailer gets the car and they sell the car to you. Now obviously if there's an implied warranty, there is implied warranty. And obviously you can sue me for breach of the implied warranty. But suppose you sell the car to Frank, and now Frank is injured by something wrong with the car, because I claim the car was fit for ordinary use, and there's something wrong so that it caught fire and burned later, and so you got out of it uninjured, but the car was destroyed. And so now the car has been destroyed and you want to sue the retailer that I bought the car from, or people further up the chain of distribution. Well, if you go up to the manufacturer made a promise that this car was fit for ordinary use, and you're saying it wasn't because through no fault of your own it caught fire and burned. And so now you say the car wasn't fit, so you want to recover. Can you recover for the car itself? And the answer is, under negligence, no. Under strict liability, no. And finally, under breach of warranty, no. You can't, unless maybe where property damage is included, a few states might let you collect, not you, but you sold it to Frank, might let Frank collect. And Frank is one step removed from you. You bought it, and your family or guests can obviously, your family or guests can sue. You can sue. Your family or guests can sue. If the car hit somebody else when it caught fire, under C, they could sue for property damage. But can you sue for can Frank sue for the damage to, let me back up for a second. If you still own the car, and you tried to sue for damage to the car, that's damage to the purchased item itself, and you cannot collect that under A, B, and probably not under C. A few jurisdictions have adopted C. They're saying that in that case you have to go to the UCC for the goods that you bought, that these goods were not what they were promised to you, and you may want to get your money back or whatever, but that's not under a products defect theory. So that takes care of the implied warranties of 2-314, merchantability, 315, fit for a particular purpose. The privity problem, there basically is no vertical privity problem. There is a horizontal privity problem. It's solved in these two ways. California says all foreseeable plaintiffs can sue. UCC says either A can sue, or the B people can sue, or the C people can sue. Now, going next to defenses to breach of warranty, First of all, if you can defeat the basic contract, I bought the car from you and the car was defective. Well, if you can defeat the basic contract, that might defeat your warranty claims. In other words, if the person sold you, if you acquired the car from X and the contract is void because of fraud, so now that the contract is void because of fraud, let's suppose the car was defective and you got injured. So can you sue for a breach of that warranty that the car was fit for the purpose intended? Can you sue for breach of that warranty if you committed fraud in acquiring the car? And it looks like the whole contract ought to be void. And indeed, you could make that argument that you maybe couldn't sue for breach of warranty, but the people riding in the car with you don't know anything about that warranty issue, and they probably ought to be able to sue. So this has never been tested, but probably if you can defeat the basic contract, you got some kind of claim, not quite sure what, but that's never been tested. Next defense to these warranty suits are disclaimers. Personal injury, the disclaimers are not effective for personal injury. You can understand that, public policy. The disclaimers to express warranties must be very conspicuous, large, bold type, saying that that there are no express warranties. The implied warranties can be disclaimed also, and but if you put any kind of a warranty, in other words, if you disclaim all things, you disclaim express warranties, you say at the time of purchase there are no express warranties, there are no implied warranties. Okay, and if you don't have an adhesion contract, then that will be effective. But the rule goes further, and it's right here on the board, and it says if you provide any type of written warranty that is in place of the express or implied warranty, if you give any kind of a written warranty, then you cannot disclaim any of the implied warranties. That's important. Finally, the defenses to these warranty actions: if you can defeat the basic contract, you might have some kind of claim. Never been tested. I think that's complicated. Disclaimers are possible defenses, not effective for personal injury. Disclaimers, if you're going to disclaim the implied warranties, you need to do it in bold writing. If you're going to say there are no express warranties, that needs to be in bold writing. And finally, if it's as is, that's a disclaimer, that needs to be bold. And finally, if you give any written warranties of any kind, then you cannot disclaim any of the implied warranties. And the final defense, besides defeating the basic contract and disclaimers, are limitations on remedies. These are sometimes put into the contract. A limitation that the seller is not liable for personal injury is unconscionable, unenforceable. However, they can require notice. They can put in the contract that if anyone is injured as a result of a defect in this product, that you need to give us notice within 30 days of the injury, for example. And what happens is that you can see how that notice can be a problem. People get injured, they're in the hospital for 2 months, and how are they going to notify the owner while they're still in the hospital, maybe unconscious? So in many situations, this notice requirement in these warranty actions is just ignored altogether. And it is certainly ignored if it's a non-purchaser who is suing, somebody who's riding in the car with the owner and driver who didn't even know anything about these notice requirements. It will certainly be waived for them. So the defenses are disclaimers and limitations on remedies. Finally, the damages you can get. If damages are to people or property, there's no problem recovering that. That type of damage is recoverable. If the damage is to the purchased equipment, the majority rule is no. In a few jurisdictions you can recover. The recovering for economic harm, you apply Hadley versus Baxendale, and if the economic harm, loss of profits, for example, is made foreseeable at the time the contract is formed, then you may be able to get that. notice you cannot get this economic harm under either negligence or strict liability unless that economic harm is connected to some other type of injury that you can collect for. Okay. Finally, warranty actions are phasing out, and they're phasing out because the warranty action is the same as a strict liability action. If you eliminate the disclaimers, in a lot of situations disclaimers just will not work. You eliminate the notice, courts are ignoring them most of the time anyway. You eliminate the limitations on damages, then it's really just a strict liability suit all over again. And so because of that, there are a lot of cases where you don't need the warranty. You just go for strict liability, they'd be the same. But warranty suits are still useful in a few situations. One is you get a 4-year statute of limitations under the UCC instead of 2 to 3 years as you would otherwise get. And secondly, you can recover these consequential damages if you can satisfy the Hadley versus Baxendale rule. Now, with all that in mind, let's look at our 3 examples again. The example from February '02 where the doctor prescribed an allergy medicine that's causing the person to go blind. Well, let's look over here at the implied warranties. The implied warranties in the allergy case would be that it is fit for the intended purpose. You have a good argument that it's not. Needed warnings and instructions, certainly warnings, didn't get any. Fit for a particular purpose, you can even claim that these were the particular purpose you were getting the meds for was for allergy. It wasn't fit for that particular purpose. You do not, in the case of allergies, you do not have the privity problem because there's no vertical privity problem, and the purchaser of the allergy medicine, well, actually the doctor prescribed the medicine, the person bought it from the pharmacy, and so the person who bought it from the pharmacy is way down in the chain of distribution. They can sue the manufacturer for the implied or express promises, but they cannot, they can sue but you don't have, my point is that you don't have a vertical privity problem because the person who took the allergy medicine can sue up the chain, and you don't have a horizontal problem because it is the purchaser who is suing. Now let's look secondly at the lawnmower problem. In the lawnmower problem, you claim that there was a breach of implied warranty because it wasn't fit for the intended purpose, because it needed adequate warnings, instructions, and they were not adequate. There are other things wrong with in the lawnmower problem. When you see it, you'll see lots of other stuff, but we're just talking about the warranties for now. In the car problem, February '06 car problem, where the child was injured, you'd say the car wasn't fit for the intended purpose, and it needed instructions and warnings, and there weren't any. There was no vertical privity problem because the manufacturer is presumed to have made this promise, but they made the promise all the way down, and then when the retailer sold it to the parent who bought the car, Oscar was his name, Oscar was the owner, and the child named Choli, well, the child named Choli is a member of the family or guest, and she's suing for personal injury. So the majority of jurisdictions have adopted and therefore under the UCC implied warranty of merchantability, the child will be able to sue because the child is in horizontal privity because the child is family or guest with Oscar. So that's how you would apply the breach of warranties to all 3 of these problems. Remember that the breach of warranty basically involves these parts of the problem. First of all, keep in mind what a warranty is. It's a promise regarding the product, has some contract aspects, has some tort aspects. If it's an express promise, any of these things, affirmations, promises, samples, models, description, all that stuff fits as an express warranty. Any of those things qualify as an express warranty. Then if you look over here at the implied warranties, the ones that are most important out of 2-314 are the warranty that the product is fit for the intended purpose or fit for ordinary use, that it's adequately packaged, adequate instructions, adequate warnings, and so if any of that has been breached, that's a breach of warranty. 2-315, fit for a particular purpose. Then there's the privity problem. We basically do not have a vertical privity problem except in these consequential damages cases because people further up the chain of distribution don't know about the consequential damages. So you won't be able to get that from the people further up the chain. Otherwise, vertical privity is kind of ignored. Everybody assumes it's there. And horizontal privity, California says anybody who's foreseeable can be affected, can sue. Other jurisdictions have adopted A, B, or C. That takes care of the privity problem. And then the defenses to a warranty problem are the disclaimers. They don't work for personal injury. They must be conspicuous if you put a disclaimer on the product. And if you disclaim any, if you give any kind of a written warranty, then you cannot disclaim the implied warranties. The way that would come up on an examination is that the person would give a written warranty, and they won't say we aren't giving any implied warranties any express warranties, because if they don't give any express warranties, they just don't have any. But the person then will might say, I am disclaiming all the implied warranties, and instead I'm giving you this warranty. Well, that's exactly what the code was designed to not allow. So if you give them any kind of a written warranty, all the implied warranties still apply. Finally, next, there are limitations on remedies that can be put in your contract. Personal injury limitations are unconscionable and void. Requirements of notice are often ignored, certainly will be ignored in the case of a non-purchaser who is suing. The kinds of damages you can recover damages to people. You may recover damages to property. As I mentioned, if a jurisdiction has adopted B, or if they're California and they're broader than that. The damage to the equipment itself, majority rule is no, you cannot recover that under a product's liability theory. And finally, you can recover the economic harm if it was foreseeable when the contract was formed, you made it foreseeable, or if the economic harm is attached to some of the physical or personal injury, you can also recover that. And that is the end of this lecture. I did mention why the warranty claims are phasing out. And again, if you get rid of the disclaimer and notice and limitations on damages, warranty claim is the same as a strict liability claim, except that you get a 4-year statute of limitations and you may be able to recover consequential damages. So that's our lecture on the breach of warranty aspect of products liability. I think it's everything you need to know about the subject, and that's the end of this lecture.